Well, good morning, Council. We're here on our second case of the morning for argument, which is the State of Kansas versus Gustin. As both council know, I'm David Bruns, former judge of the Shawnee County District Court, and have been on the Court of Appeals since 2011. I'm pleased today to be sitting with former Chief Judge Tom Malone, who sat on the Sedgwick County District Court bench for many years before being appointed to the Kansas Court of Appeals in 2003. And it's also an honor to be sitting today with Senior Judge Richard Walker, who served 18 years, many years as Chief Judge of the District Court in the 9th Judicial District, and has been sitting as a Senior Judge with our court since 2015. As you know, you both have 15 minutes for argument. And Mr. Joseph, as the appellant, would you like to reserve any of your 15 minutes for rebuttal?
Sure. Could I have 3 minutes?
Certainly. So 12 and 3. And with that, Mr. Joseph, you may proceed.
Thank you. Chris Joseph, again, appearing on behalf of Mr. Gustin. This was an attempted murder and kidnapping trial with rather gruesome facts that led to a verdict that supported the attempted murder, but fell short in terms of substantial evidence to support the kidnapping charge. Certainly short on all 4 alternative means that were presented to the jury in the instruction. It's really a case, in my view, of difficult facts, bad facts, gruesome facts, leading to convictions that maybe really aren't supported by the law. This appeal calls into issue 4 parts of the Kansas kidnapping statute. The first are the words taking and confinement. Those are both in subsection A. They are alternative means. A kidnapping requires either of them, either a taking or confinement. The next are subsections A2 and A3. A2 is the facilitation provision that turns on the application of the 3-part facilitation test our Supreme Court set out in the Buggs case. And A3 is the bodily injury provision. Now, the jury instruction presented all 4 of these alternative means to the jury trial, or to the jury in Gustin. A reversal is therefore required if the evidence was insufficient on any one of the alternative means, and that would be a reversal for and remand for retrial. An outright reversal, however, with no retrial is required if the evidence is insufficient on both the taking and confinement provisions in subsection A. I believe that's ultimately the case and would ask the court to reverse without a remand for new trial.
Mr. Joseph, just to give me a little background to make sure I understand what happened. First of all, were you the trial counsel on this?
I was not, no.
You were not? Okay. And so maybe you won't know the answer to this, but I'm just wondering how it came to pass that all 4 alternatives were presented in the jury instruction.
I don't know the answer to that. I mean, in my review of the record, the first thing I do is I grab the jury instructions and look, and I saw that and said, wow, okay.
Because often we'd see those pared down to maybe 1 or 2, depending on the facts. Okay.
And I think it may be simply a strategic mistake on the part of the prosecution, because frankly, they'd have been better off if they were selecting confinement or selecting just, frankly, they should have, in my opinion, done confinement only and maybe the A3, but they presented all 4. And as a result, the jury, you have to have unanimous decision. And we don't know unless the evidence is just strong enough to support all 4. Without sufficient evidence for any of them, you need a new trial. And again, since a kidnapping requires both a taking or a confinement, those 2 are mandatory. If you don't have a taking or a confinement, it's just an outright reversal. There's no retrial. So let's talk about the 4. I'm going to start with the taking. Now, our Supreme Court in Haberline said that taking and confinement are alternative means. The state suggests that it's mere dicta. I would caution against taking that approach. The reason is that Haberline interprets subsection A, and it interprets the whole subsection. It explains that taking and confinement are distinct acts that are being modified by this other phrase, force, threat, or deception. So it's really integral to the decision in Haberline. I don't consider that mere dicta, but it's also correct. Subsequent precedent makes it pretty clear that that's exactly what the court meant. If you take a look at the Buggs decision, the Buggs decision is using the word taking and movement as synonyms, right? So it's interchangeable. The Buggs court essentially defines a taking as movement, and quite plainly, confinement is not a movement. So not only in Haberline is it saying specifically that there are alternative means, but subsequent precedent makes it quite clear that the court's interpreting taking to be a movement, which is different than a mere confinement. Now, what is a taking?
I'm sorry to interrupt you, Mr. Joseph.
Yeah.
What about the Lloyd and the Ross cases, which take the approach that, in fact, quoting from Lloyd, the Kansas legislature does not intend for the terms taking and confining to be separate alternative means of committing kidnapping, as evidenced by the statutory structure our lawmakers chose to employ. So, and I realize those are unpublished decisions, but aren't they more persuasive than what looks to me like dicta in Haberline?
No, I mean, first of all, Lloyd is an unpublished decision. Haberline, I mean, you can call it dicta, but it is the Supreme Court saying it is an alternative means. And then you look at Buggs, and Buggs is saying, here's what taking means. And you can't square that with confinement. They're just simply different acts, right? I mean, it's not just Haberline. If you look at the subsequent opinion, they are defined differently. A movement is not a confinement, right? I mean, so that's the explanation that you get in Haberline, is they're different acts, right? And then the subsequent decisions make it very clear that taking is a movement. And I don't care if you look at the Webster's dictionary, they're saying it's a movement, and a confinement is the opposite of a movement. So they're different acts, and the published Kansas Supreme Court cases make that pretty clear. And I think that's call Haberline what you want. I think it's integral to their decision. Call it dicta if you want. Looking at subsequent published Supreme Court opinion, a taking is a movement. It's got to move somebody. And look at the Burden case, another published Kansas Supreme Court case that tells us what is sufficient for a taking, with somewhat similar facts. The victim in that case was attempting to get out the front door, very similar to this case. What was sufficient for a taking was that the victim was taken down the hall and into a bedroom, and that was a movement that was sufficient for a taking. So in contrast, what do we have in this case? In this case, and I know the state quotes some language that the victim Audrey used about, I got pulled back in. But if you read through that trial transcript, it begins on page 117 and it goes thereafter. It's very clear that everything, the entire attempted murder, happened right at that front door, right in the linoleum. And if you look at the descriptions of Exhibit 6, as Exhibits 5, 6, 7, all the blood is right there. Everything is there. She attempts to open the door. The next thing she remembers, she's stabbed in the back. She didn't see the knife in the back of her neck. Everything is right there at the front door. So there really is no movement. And contrast to Burden, there's no taking, there's no movement. It all happens right there at the front door. And ultimately, without any kind of movement from that front door, you have no taking. And I think that is a very clear conclusion that you need to reach, is that everything happened right there at the front door. The stabbing, holding her down, choking her, it was all right there. There's no movement from that front door entry area. The second alternative means is a confinement. I agree that Chris did restrain Audrey when he pinned her down to the ground at that front door. But that was kind of part and parcel to this attempted murder verdict. He's holding her down, specifically says trying to hold her down to bleed out. I mean, again, these are gruesome facts. He tries to choke her to death. He's waiting for her to die, essentially, as he pins her to the ground. These are the means to the attempted murder. There's nothing separate from that would constitute a confinement independent of the attempted murder. And it seems this pinning her down to the ground would be short of the type of confinement that the legislature intended for a kidnapping. And if you look at the Buggs case, the classic confinement cases that they described are holding a victim for ransom, a forced removal to a dark alley for robbery, or locking a clerk in a cooler to facilitate escape. Here, this is just part of the attempted murder, and it's not a confinement in that sense. But if it is a confinement, if it's more than a restraint, a mere restraint, it begs the question of whether or not you have to have some kind of confinement that is separate and apart, in addition to the acts that constitute the underlying crime of the attempted murder. And I think the answer is in Buggs. And Buggs is not, and this may be mere dicta, but it really is illuminating the court's thinking. The court says, we agree with those courts, referencing other opinions, that a kidnapping statute is not reasonably intended to cover movements and confinements which are merely incidental to the commission of the underlying crime. So what they're saying.
So pinning her down for 30 minutes after he'd already stabbed her was not confining her?
It's certainly a restraint. Whether or not that constitutes what is considered a confinement in the traditional sense of the statute, I would suggest it's not a true confinement as that term is meant in the by the legislature. However, if it is, my point is that even if that is a confinement and not a restraint, it is part and parcel of the attempted murder. And what the Buggs court is saying is that, look, not every rape, not every robbery becomes automatically a conviction for kidnapping. It has to be something more, right? It has to be something more than the conduct that is part of the underlying offense. In this case, holding her down was part of the attempt to get her to bleed out, to choke her, to kill her. It was the evidence that supported the attempted murder. There was no additional restraint or confinement separate and apart from the underlying act. So
couldn't reasonable people disagree on that, though? Isn't that why we have a jury? It sounds like two reasonable people on this in this hearing might disagree over whether that this evidence supports confinement. And that seems like that's a jury issue, is whether this evidence reaches that level. Is this a confinement or not? I mean, you got good arguments both ways.
Well, I think this is a question of one, statutory interpretation of what the legislature meant by confinement. Is that part of it? And number two, it's certainly a question of pure law as to whether or not there has to be a confinement that is separate and apart from the underlying criminal act. So do you have to have a confinement that's not the means of the attempted murder? Do you have to have a confinement that is not part of, and again, this is why the Buggs case talks about an ordinary rape is necessarily going to require some restraint and confinement, but that's not going to support, as a matter of law, a kidnapping conviction as well. There's always some element of restraint and confinement in a rape. But what the principle that Buggs is setting out is you don't automatically have a kidnapping in every rape, right? You need more. If instead they locked her in and then raped her, that's a confinement. Locking her in the house and raping her, that's a confinement that could constitute a kidnapping. If he ties her before he runs away to flee, that's a confinement that could be separate and apart from the rape. But you can't just convert every crime that involves some element of restraint, movement, confinement, to make it also a kidnapping case.
But unlike rape, attempted murder does not necessarily inherently involve confinement.
Correct.
I mean, a matter of fact, I think you pointed out he stabbed her in the back as she either is trying to get out the door or not.
I agree.
Where rape, inherently, there is some restraint involved.
I agree with that. And the test that I'm suggesting is that the court means by this in Buggs is not the inherent nature of the crime, but in this case, the way it was carried out. And the attempted murder included the stabbing and then holding her down in the attempt to get her to bleed out. I mean, that's the evidence. So in this case, it did. No, not all attempted murders. I mean, you could shoot somebody and run away. I mean, there's no confinement or restraint in that. But the way that this played out, the evidence that supported the attempted murder in this particular case, that was part of the attempted murder. So it isn't something you can parse out and say that was separate and above. It was an additional confinement or restraint that was, you just can't. It was part of it.
You are over your 12 minutes, so you might want to wrap this portion up if you want to save some rebuttal.
Sure. And I'll just point out the third factor, the third alternative means is the facilitating flight or attempted murder. And that's the 3-part Buggs test. And it's essentially the same analysis I just went through. If it is incidental to the other crime, meaning part of the additional crime, the restraint is part of the attempted murder, that ends it. Frankly, I think the subpart 3, A3 is just, or A2 is just the evidence isn't there. And that at very least requires a reversal and a remand for new trial.
Okay.
Thank you.
Thank you. Thank you, Mr. Joseph. Mr. Wire?
Thank you. May it please the court. My name is Curtis Wire and I represent the state of Kansas. There are two issues in this appeal, and I want to start with Judge Walker's question regarding Haberline and the dictum. I think that this court has laid out in a few other opinions a pretty compelling argument for why that is dictum. And now that the issue is squarely briefed to this court, it should take up that issue. And we can tell that the legislature intended, we can tell that they did not intend taking or confining to be alternative means, but options within means from two primary sources. The first is the structure of the statute. The legislature listed the alternative elements in A1 through A4, clearly separating them with semicolons and different subsections, which unambiguously demonstrate the alternative means of committing aggravated kidnapping. For instance, in State v. Brown, the Kansas Supreme Court looked primarily at the structure of the indecent liberties with a child statute and concluded that the distinct subsections similar to this statute here set forth alternative means of committing the crime. Another reason we know that taking or confining are options within a means is that the plain meanings of taking and confining overlap considerably. As I laid out in the brief, confining is defined as to enclose within bounds, limit or restrict, to shut or keep in, prevent from leaving. Similarly, take is to hold, grasp, grip, seize or capture, catch or get into one's possession by control or force. And I think this case actually serves as a pretty good example of how somebody can both confine and take a victim. Audrey was prevented from leaving her apartment by Christopher's grabbing, pulling, tackling, and pinning her on the ground. It can also be said that Christopher took her by forcibly getting her into his possession by catching, holding, grasping, and gripping her. So I think the definitional overlap also strongly suggests that taking or confining are alternative means. Now, assuming that this court feels compelled to go ahead and hold that they are, in fact, alternative means, we still think the state has plenty of evidence that Christopher both took and confined Audrey. The other side really keys in on the taking of Audrey and its perceived lack of evidence there. However, as we point out in the brief, when Christopher stepped away, there are two different acts here the state is alleging. When there was the initial attack on Audrey where she was hit in the back of the head, she was knocked to the ground, and then she got up to escape. And the testimony is that she got all the way to the door, had her hand on the door, was clearly trying to escape to seek help. A reasonable juror could infer from the evidence that she was attempting to get out to seek help. However, Christopher had left to get the knife, had come back, and according to her testimony, he grabbed her and pulled her away from the door, and at that point stabbed her. Now, of course, the other side makes a lot of the fact that this didn't cover much distance, that even moving from the door back a ways to be stabbed, they talk about how the lack of movement here. But Buggs was emphatic that there is no minimum distance that needs to be traveled in order to meet a taking or confining here. In fact, much of the Buggs decision is a juxtaposition of the model penal code, which required a substantial distance that must be covered. And our Supreme Court stated under the present statute, our statute, it is still the fact, not the distance of the taking, or the fact, not the time or place of confinement, that supplies the necessary element of kidnapping. So while these facts are obviously different from maybe a quote unquote more classic kidnapping statute, it's no less kidnapping because there is no minimum distance that needs to be covered. We also think that returning to taking, that there's plenty of evidence that Christopher took Audrey under the definitions I listed before. He took her when she was on the ground, he pinned her, and he took her into her possession by force. So a plain, unambiguous understanding of the term can be met there with that evidence as well. Now moving to A2 of the statute, because taking and confining, of course, in our structure analysis, is housed wholly within A. The facilitate, flight, or commission of the crime. This was an actual issue in Haberline, which held that either of these are not alternative means, but options within a means. So evidence of either one of these is sufficient for this court to uphold Christopher's conviction as to A2. There was not slight inconsequential. The confinement regarding the commission of attempted murder was not slight or inconsequential. The grabbing, pulling, holding a mother, or grabbing a mother holding two kids is not slight. Neither was pinning Audrey on the ground. It was not inherent in the nature of the other crime. The inherent force in this case with attempted murder, as Judge Bruns was alluding to in his questions there, is rather than in a rape case here, a murder, the inherent force are the stabs, the blows from the knife to Audrey's neck. So we're talking about a different type of force, the grabbing, pulling, tackling, and pinning of Audrey. The tackling part, I want to note, was part of his testimony, or his admission, perhaps during the interview, that he tackled her by the door. And again, there is independent significance here. The force that Christopher used gave him an advantage in attempting to kill Audrey, and it also prevented her from escaping and getting help, which we know is what she's attempting to do. She talks about banging her feet on the floor, yelling, hollering, trying to get somebody to know that she's being attacked. And then when she is actually able to escape, she flees to neighbors trying to seek help. So a reasonable juror could conclude that Christopher holding her on the ground is preventing her escape and thereby facilitating the attempted murder.
Mr. Wired, would you address head on what I think is one of Mr. Joseph's strongest arguments, which is that, okay, the holding, the pinning down, this was all subsumed within the act of attempted murder. It wasn't an independent act. It was all part of the same attempted murder and not a separate act.
Yes, Your Honor. As we talk about it,
particularly because, I mean, he was attempting to get her to bleed out. Well, obviously, he didn't know how much time that was going to be. So was the argument that I hear him making is, well, it may be terrible, but it was all part of the attempted murder, not something separate. Go ahead. I'm
Sure.
sorry.
No, I thank you for directing me to that. Yes, as we argued in the brief, there's actually a dual purpose, well, at least a dual purpose of what's going on there when he's pinning her on the ground. Yes, he states that he's hoping that she bleeds out, but according to his testimony, he realized at some point in that interaction that she was not going to bleed out. And so he was holding her down in an attempt to devise a plan to escape. A further illustration of this is, so at the point that Christopher attacks Audrey and stabs her, the knife blows go into her neck, and the knife goes away and he's holding her. At that point, he could be convicted of attempted murder. That crime is complete. So holding her on the ground is, it might be attempting to actually kill her, which he was unsuccessful in doing. Otherwise, we would have a whole nother crime here. But at some point, she begins pleading with him and trying to figure out a way to get him to release her so that she can escape. And so there's this back and forth between them. We don't know for how long, but there's the 30 minutes that he's holding her down. And she is able to eventually trick him into letting her up. So while it can be said that he may have intended to hold her down and attempting to kill her, that doesn't mean he didn't have other purposes while he was on top of her, holding her down. And those other purposes are what meet the bugs restrictions here for upholding the aggravated kidnapping. I hope that answers your question, Judge Walker.
Yes, thank you.
I'm sorry, I forgot to start my timer.
You're at about little over 9 minutes.
Okay, thank you. I also want to point out too, on that point, that while the attempted murder had been completed by the time he had stabbed her, the other act that we are alleging also meets taking or confining is the grabbing and pulling away from the door. Similar to my prior point, Christopher could have just as easily stabbed Audrey at the door. When he obtained the knife and Audrey had made it to the door, he could have simply just stabbed her there. But she had her hand on the door handle and was trying to escape. He instead grabbed her and pulled her back into the apartment. Granted, it might not have been a long distance, but as we've already established, distance doesn't matter. He pulls her back into the apartment and stabs her there, whereas he could have just stabbed her at the door. So of course, so this force also constitutes a confining and taking. So either one of these acts would be sufficient to uphold Christopher's aggravated kidnapping. I don't have much else. Does the panel have any questions for me?
Panel have any other questions? No. Thank you, Mr. Wire. Mr. Joseph, rebuttal.
I don't think you can parse out the attempted murder as sure stabbing her was part of it, but holding her on the ground, choking her, trying to get her to bleed out were also part of the evidence that supported it. I don't think you can say there's a dual purpose. Well, who knows what was going through his head? At some point, the evidence says he realized she wasn't going to bleed out, and he let her up and tried to get her to go in the car. But before that, he's choking her, sitting on her, beating her, trying to kill her. That's all part of the attempted murder. So, the moment that, as far as I read the record, the confinement ended when he decided he wasn't going to bleed out and he's going to take her in the car. Before that, again, there's no taking because he stabs her in the back of the neck at the door. Everything is right in front of the door. So the description of Exhibit 6 is the blood's all right in the entryway, right by the door. No movement, no taking. The confinement is exclusively part of the attempted murder. Now, sure, he could have done things differently. He could have pulled out a gun and shot her, but he didn't. All the restraint and choking and holding and attempting to bleed out were part of the evidence that supports attempted murder. There was nothing independent of that. Mr. Weir is essentially speculating about thoughts that he may have had. It also served a dual purpose. But the point is, it was part of the attempted murder. There's no additional confinement beyond what was the attempted murder. And because
I'm going to have to go back and take a look at the record, but Mr. Weir just made the argument that he could have stabbed her at the door. Instead, he grabbed her and pulled her away from the door in order to facilitate this. Isn't that a taking? I mean, if that's true, and I can't remember the record well enough to know whether that's a precise description.
I've read that multiple times because that is the only language the state points to that might support a taking. If you go read that, it's on page 117, and it continues for the next number of pages. She does use that phrase. But then it's clarified to the prosecutor, and the prosecutor clarifies that she tries to grab the door handle. The next thing she remembers is getting stabbed in the neck right then and there. So she does use a phrase like that, but the blood evidence shows it's all right at the door. And she clarifies later that the next thing after grabbing the door is getting stabbed in the neck. So I don't know what she meant by that, but it's kind of a one-off comment that does not fit the balance of the evidence. And quite clearly, there was no movement because it's all, again, the blood evidence, everything is right there in front of the door where he stabbed her and took her to the ground and waited for her to bleed out. But I do recognize that phrase that Mr. Weir picked out is something, but it's not enough when you look at the record as a whole, because that is immediately clarified by the prosecutor. There is no pulling her away from the door. It is just the next thing she remembers is being stabbed in the neck from the back while at the door, and then goes to the ground right there. So there is no movement in the sense of a taking. And truly, the confinement was all part of the attempted murder.
Okay, thank you for clarifying that.
Any other questions from the panel? If not, thank you, counsel. Good arguments. We will take this case under advisement and get an opinion out to you as soon as we can. Thank you.